Thank you, Mr. Crane. Ms. Vaughan.
Thank you very much for the opportunity to be here today to discuss H.R. 2497. Our work at the Center for Immigration Studies is focused on examining the impact of all forms of immigration on American society and the effects of any proposed changes to our immigration policies. In my analysis, this bill would not have much of an effect on immigration levels, on immigration law enforcement, or on how the immigration agencies and their staff routinely do their jobs. But what it would do is to prevent any further harm to Americans and legal workers that would result if the White House or its appointees in the immigration agencies were able to expand their efforts to bring about an unpopular and ill-advised legalization scheme through executive action. Just to set the stage, the last decade was the largest 10 years of immigration in American history. About 13 million immigrants settled here, legally and illegally. We also admitted several 100,000 guest workers over the same time period every year. Meanwhile, our economy lost 1 million jobs over that same decade. In 2008 and 2009 alone, 2.4 million new immigrants settled here, while 8.2 million jobs were lost in our economy. In this economic climate, it's pretty hard to make the case that immigration regulations should be relaxed to permit illegal workers to stay, especially when most of them would be vying for the very same jobs as many unemployed U.S. workers, and where there's already an oversupply of labor. Yet that's exactly what the Obama administration says it wants to do. In various public statements and memoranda, officials say that the goals are to wave in as many immigrants as possible, to drastically scale back immigration law enforcement, and to legalize as many of the 11 million illegal aliens as possible. And it's not just talk. They've been acting on these plans. For example, telling consular officers and benefits adjudicators to overlook things that should disqualify applicants, or restricting what ICE field office staff can do, telling ICE lawyers to drop charges on thousands of illegal aliens at a time, or letting sanctuary states stay out of secure communities. These actions display a shocking disregard for the public trust and for congressional authority over immigration law, not to mention the wishes of Americans. At least 2/3 of voters consistently express a desire to see stricter immigration law enforcement, not weaker. Polls show that only about 1/4 of voters approve of the way the Obama administration has handled immigration policy. They understand all of the costs and problems. That is why over the last 5 years, Congress has repeatedly declined to authorize an amnesty or legalization program on any scale. It's important to consider, too, that there's no shortage of qualified immigrants who are willing to play by the rules and go through the process the right way. At last count, the State Department reported that there were nearly 3 million people who've been sponsored for green cards who are waiting their turn overseas, and some of them for as long as 15 years. Offering illegal immigrants a path to residency in front of these applicants is patently unfair and undermines our legal immigration system. And not enforcing immigration laws just exacerbates the crime and public safety problems. According to ICE statistics, there are nearly 2 million criminal aliens living here, more than half of whom are at large in our communities. ICE's focus on just the worst of the worst through excessive prosecutorial discretion and stingy use of detention leaves too many of the worst still on our streets. And as a result, people are getting hurt needlessly. People like 10-year-old Anthony Moore, who a couple of months ago was walking to the bus stop in Florida when he was mowed down and killed by an unlicensed illegal alien driver. This illegal immigrant had at least 2 prior charges for DUI and a probation violation, but he was not enough of a priority either for Florida prosecutors or ICE to take action before the fatal accident. And this kind of story is repeated over and over again all over the country far too regularly. So the lack of enforcement is bad enough, but apprehension numbers for ICE, as opposed to removal numbers, have actually been going down for several years, according to ICE statistics. But just declining to arrest or remove an illegal alien does not give that person real legal status. To accomplish that, the administration has to rely on the parts of immigration law that are specified in this bill. These tools are designed to be used for exceptionally compelling cases. They're immigration law luxuries, and not intended as a way for the executive branch to bypass Congress and its unique authority to make immigration law. Again, while the administration claims that these are only ideas, in fact, they already have begun trying out different forms of administrative amnesty. For example, by relaxing the extreme hardship standard for the illegal aliens who try to apply for green cards but are disqualified and come under the 3-year tenure bar. Last year, about 19,000 people in that category successfully obtained extreme hardship waivers. And you have to ask yourself, how extreme can these cases be if that many people are able to qualify every year? And the percentage of people who qualify has about quadrupled in the last 4 years. Common sense tells you these aren't extreme hardship cases. They're certainly bitterly disappointed to be denied, perhaps financially stressed, and inconvenienced certainly, but not really facing what the law defines as extreme hardship. The fact that the administration has already started tinkering with forms of relief, I think, illustrates the need for this legislation. The tool of deferred action is especially susceptible to abuse since there are no statutory guidelines and the agency has never publicly published statistics on how often it is used, so no one can monitor what is being done.
Could you please wrap up? We appreciate your testimony, but we really need to stick with the time limits.
So this bill would help uphold sound principles for immigration policy, namely that immigration to the United States should occur through legal, fair, and open processes.
Ms. Vaughan, is it appropriate for the administration to use deferred action and other types of prosecutorial discretion in order to achieve the policy goals that Congress has clearly rejected?
No, absolutely not. I mean, Congress has the authority to make immigration laws, and while the executive branch needs some discretion for the most exceptional cases sometimes, it's not appropriate to use these tools to bypass Congress when it can't get its way. And I think deferred action has the potential to be abused on a very grand scale if Congress were not to exercise some oversight over the administration. Because it doesn't have a statutory basis, like there are definitions for temporary protected status and for other parts, some of the other forms of relief that are listed in the bill. But deferred action has not been utilized in the same way and doesn't have the same kind of controls on it. And deferred action is also one specific form of relief that has been put out there to be used for a general amnesty in memos that were circulated within USCIS. So it's clear that that's been the plan.
That actually takes me to my next question to Ms. Vaughan. Do you feel that administration policy has already resulted in some innocent Americans losing their lives and in other innocent Americans being unnecessarily injured or maimed?
Yes, I do. I feel quite confident that that's the case, not just Americans, but also immigrants as well. There was one case up near where I live in Massachusetts of a woman and her 4-year-old son who were murdered by an illegal alien who had been arrested and charged with acts of violence on more than one occasion before, both in New York State and in Massachusetts, and who was not detected because he used false names. If the Secure Communities program, for example, had been in place, he would have been detected. And I have heard from individuals who are in a position to know that that's a case that they would have prioritized if they had known that he had been arrested. And but the ICE is allowing states effectively to not participate in secure communities for political reasons. They have not required Massachusetts to participate, even though they have both the mandate and the authority to do so. Yeah. So I believe that her life and her son's life, as does the district attorney who is now trying to extradite that former illegal alien from Ecuador, also believes that it would have saved 2 lives in that situation.
Yeah, and I assume that there are dozens, if not hundreds or thousands of similar cases across the country where crimes were committed by individuals who should not have been allowed to remain in our country.
Definitely. Their family members often write to me and ask what can be done.
Okay.